New Year's Eve party in Warren County ended in gunfire. One person's in the hospital fighting to recover. Police say it started after a woman became angry over her ex and her boyfriend hanging out.
State of Ohio versus Olivia Clendenin. Case number is 25CR42324. Ms. Clendenin is present with her counsel, Lindsay Arway. The state is represented by Brian Goodyear. We're here for a bond hearing. What's the request?
Thank you very much, Your Honor. Ms. Clendenin, I believe, is actually requesting to have the monitor removed, understanding that that is a pretty lofty request. The basis for that request, Your Honor, is that at this point, I know that she has her main employment with the cheer and tumbling facility. However, she is also working, is it Soiree, is that how you say it? Soiree Wellness, which is actually LA Tan, and she is up for a promotion with that company into management. As part of that promotion, which she tells me they are looking to officially promote her as of January 1st of 2025, she would be required to have a dress code. I don't know that the dress code's necessarily the biggest issue. I think the biggest issue is that as part of her promotion, she would be required to utilize some of the wellness services so that she's able to appropriately advise customers and clients as to those services, and it has the potential to very much damage the monitor itself. And I know that those are very expensive. I think we had a client who was told that they cost somewhere in the range of $3,000. So as part of testing these products and services that are available through the company, which is required as a management position, it has the potential and likelihood almost to, in fact, damage the device itself. I was also provided, if Your Honor would like to take a look at it, with a copy of the company policy on management guidelines and dress code from Ms. Clendenin, which notes that it is their official policy, and it does have their Soiree Wellness LA Tan information on it for Your Honor to take a look at, that represents that this is something that is required for the position. I know that in the event that Your Honor is not inclined to grant the removal, that Ms. Clendenin also is looking to have, perhaps if Your Honor would consider open hours. It's my understanding that, LA Tan and the wellness company as a whole, they're Saturdays, they're Sundays, so they're open 7 days a week. And as part of her management position, she would be required to go in the event that an employee calls off. It would fall on her shoulders in order to be the one that actually goes in. And I believe at this point it would be difficult if that were to be during hours when the court or probation or pretrial are not open for her to be able to get permission in order to do that. So I think that I've covered the gist of what we're asking for, correct? The hours as well as the
dress code,
okay.
the services, yes.
And again, Your Honor, I do have that form here with the rules and regulations if you would like to take a look at that.
Oh, just a moment. Anything from the state?
Your Honor, this is like deja vu all over again. Ms. Clendenin was almost exactly this many days from the last jury trial setting when she asked this court to remove her monitor at that time. The court had a chance to consider that request, denied that request, and then shortly thereafter, Ms. Clendenin fired her attorney, from my perspective, for reasons that I still don't understand. I know for a fact, in speaking with him at the time, that Ms. Clendenin never even spoke with him about it. She never gave him any reasons. There was never any problems, any concerns. He just found out she had a new attorney. So, Your Honor, I just bring this back initially to the fact that she's charged with attempted murder, and she nearly killed someone. And she confessed to the fact that she nearly killed someone. And luckily for her, she had people with resources sufficient to secure her release from jail. And I understand that as the motion mentions, she's not tested positive for any drugs during the time she's been out. However, having said that, the state's main concern is her appearance at trial. The fact that she tried to get off the monitor 30 days before trial the last time, it was denied. She finds a way to continue the trial. Now here we are once again, the same period of time before trial, asking again. It just is very concerning to the state that what really is happening is she's trying to get a 30-day head start. She knows, I'm sure, like everyone else knows, if you cut that monitor off, they know immediately it's done, and they'll come out and they'll try and arrest you immediately. You know, Judge, this is just such an odd conversation to have. I'm about to be a manager on January 1st, but I'm going to trial on January 26th in a case where, Judge, even if she's only convicted of improperly discharge of a firearm into a habitation, if that's the only conviction she receives, to which she confessed, she faces a minimum of 10 years in prison. Minimum of 10 years in prison. So she has a massive incentive to run, to not appear for trial. And frankly, it makes this thinking, this motion, to me, almost nonsensical. You're going to be a manager for 25 days, and then you're facing a minimum of, best case scenario, probably, with the charges that exist, 10 years in prison. So I think that, Judge, it's the state's perspective that the overall situation here is very concerning. We would ask you to deny both the requests. You know, she's facing serious prison time on serious charges, and I think she's been given a lot of leeway up until this point considering those factors. So the state would ask you to deny both. Judge, the victim's mother is present. She would like to address the court as well.
Okay.
Would you like for us to step to the
No,
side?
she can just use the table there. Do you have any paperwork that you're
No,
working?
not at all. Not at all. Let
Okay.
me just move this out of the way here.
Yeah, that red light's what's important, ma'am. It's the microphone.
Okay.
Go ahead.
I just wanted to speak on behalf of my son. I heard what this was about today, and I think it's absolutely absurd that she's requesting this when my son can't even hold a job down since this happened because of the injuries that he's sustained, the stress that he's gone through, the mental anguish that he's experiencing because of her actions, and that she has the audacity to come in here and ask for this to happen before the trial because she would like a management position with a job that she's holding right now. It just makes no sense to me whatsoever, Your Honor, when my son, because of her actions, can't even hold a job down right now. I can't believe that she's even asking that. So that's all I wanted to say.
Okay, well, you said it well. That's a logical statement. Understand. So thank you.
Thank you, appreciate it.
Okay.
My name is Misty Johnson. Yes, thank you.
So basically, she's presumed innocent as far as where we are on this. I'd already sort of come to this conclusion before I heard from the victim's mother, but it makes a lot of sense. I mean, when something happens like this, there are consequences. And I don't think she's going to run. I don't believe that. I'm not concerned about that at all.
I would suggest that's not a concern as well, Your Honor.
She's, number one, shown she can comply. I mean, this probably, regardless of the attitudes about it and the understandable attitudes about it, it seems like a very unusual thing given her history, but it happened. And it doesn't make sense to go ahead and make these changes. Here we are 30 days from trial. There were two requests. One was
So one was to remove the monitor, Your Honor,
Yeah,
and the second request was somewhat with the first request in the sense that the management position would also require her to go in and cover, but I would indicate that as a second request, in the event that the monitor is not going to be removed, that perhaps she be granted open hours as it relates to the fact that she's not had any contact with anyone. Your Honor's noted she's demonstrated her ability to appear and her full compliance with everything up to this point. And I think the reason for that is it would at least give her the opportunity to assist in covering things for the company in the event that that's needed, or for her to be able to pick up the additional time.
What time do they close?
9 p.m.
Okay. All right, so the request is denied. I will modify her hours from 6 a.m. till 10 p.m. However, on New Year's Eve, you stay home. You still can't consume alcohol. That's a rule. Anything from the state?
No, Your Honor.
Anything else, Ms. Arway?
No, Judge. Thank you very much, Your Honor.
That's it.
New Year's Eve party in Warren County ended in gunfire. One person's in the hospital fighting to recover. Police say it started after a woman became angry over her ex and her boyfriend hanging out. Ken Brown is live outside of the Warren County Jail and the courthouse, where he is locked up facing attempted murder charge. Ken?
Yeah, that woman's name is Olivia Clendenin. She's locked up in the jail off screen to my left here, and tomorrow she will face a judge in the courthouse behind me.
Early on New Year's Day, Clear Creek Township police got a call to this home along Dearth Road for a man shot.
The initial call was the belief that it was a drive-by shooting. When the officers got there, they did find one individual had been shot in the stomach.
Inside the home, a celebration of the new year was happening overnight, but it wasn't until 5 in the morning when the fun ended with gunfire.
It was a New Year's Eve party. There was a girl that was involved with a boyfriend there, and her husband was there. I believe they're in the process of maybe divorcing, but maybe had not completed that yet.
Outlined in Clear Creek Township's police report are witness statements that say Clendenin was not happy with her ex and her boyfriend hanging out together.
There was kind of this three-way argument going on at the party. At one point in time, we understand that she left the party, returned. The argument continued.
Police say that verbal argument turned much more serious when Clendenin left the party a second time.
She had obtained a gun, and when she drove, she actually did a kind of a donut in the front yard, which put the driver's side toward the front of the house. The driveway's on the left-hand side of the house. She did a donut in the front yard, and as she passed the front door area, she fired off a couple shots.
One of those hit a man in the stomach. Police say the man hit was not involved in the earlier arguments. He was taken to the hospital and has already undergone one surgery. Police said as of last night, he's expected to survive. After firing the shots, the chief says Clendenin tried to drive off, but that didn't end well either.
Ended up going down the road and crashing out her car, where she sustained some injuries.
Olivia Clendenin is due in the courtroom and the courthouse behind me at 2:30 tomorrow. Jail records indicate she's facing 5 felonies. Police tell us the most serious among them is an attempted murder charge. Reporting live in Lebanon, Ken Brown, Fox 19 Now.